Good morning. We're here for oral argument in case 1CACV 180702, Hart versus Biederbeck. These proceedings are being video and audio recorded, so we ask counsel to please identify yourselves and your clients at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we have read the briefs and have discussed this case in conference. With that, counsel, you may proceed.
Good morning. May it please the court. My name is David Abney. I'm here representing the plaintiff, appellant. My basic thesis is that there's three things that we need to prove in order to show an entitlement to punitive damages. One is an intent to injure. The second would be the proof of injury, which the trial court has supplied for us by holding that there was injury, and the receipt of an award of actual damages. Once you have those three things in place, then I submit that there is an entitlement to an award of punitive damages at that point, whether the amount, but the amount, of course, would be subject to the discretion of the fact finder. In this case,
could the amount be $1?
Your Honor, I think it could be $1, although I think more logically and properly, in accordance with the case law, it would be some sort of meaningful award. There's talk in the cases about shocking the conscience of the court and disproportionality. So $1 may be disproportional to the $15,000 award. But
you're saying it's automatic in any intentional tort that there should be an award of punitive damages?
Under the circumstances of these intentional torts, we had three. You had the trifecta. You had the assault, battery, and intentional infliction of emotional distress. So I don't think there could be any quibble that there was intent to injure. I was looking at the Raji this morning, and that's the first one of this different elements that you need to show the mind, the evil mind, to support punitive damages, was intending to injure. And here we've got that in triplicate.
Let's start with the basics. Let's talk about the standard of review. You're arguing that it's unclear and we should apply a de novo standard in this case. Is that correct?
That was my argument. It's not the strongest argument I've ever made in any appellate court by any means. I was confused when I went to try to find what the proper standard was. I always want to find a de novo standard if I can, although I'm not quite sure in this case if that was really what I should have been looking for, but I found some cases that talked about the de novo standard. My colleague across the aisle says it's abuse of discretion, and if that's what it is, there are cases that say it's abuse of discretion. So it may indeed be abuse of discretion.
Doesn't it make sense to be an abuse of discretion standard, given that it's credibility driven and trying to decide exactly how evil someone is? Isn't that something we would defer to the trial court on?
I don't know if it's trying to find the evilness. I mean, the evil mind is established. And it's the other circumstances that go with it, the injury.
Well, and where is how is it established as opposed to just an intent to injure? You're just saying that necessarily equates to evil? An intent to injure is can always be equated with being evil?
I think so. You look at the comments to the Raji, and there was a discussion in the comments about, well, should we put evil mind in the instructions or not? And there was an opinion that, no, we really shouldn't do that because people might think in religious terms or social terms or behavior terms. So they came across, well, you have to have this specific kind of mental state. And one of them is intent, and here we have intent established. Otherwise, you get into questions of conscious disregard, deliberate indifference, and you're off in the fields forever trying to figure that out. But here with intent, you've got the evil mind. The instruction doesn't say evil mind, but there's a reason why it doesn't say that.
Let's go back to my question. You're conceding that the standard of review is abuse of discretion?
Essentially, yes, Your Honor, I am conceding that.
All right. Given that, how do we address this differently? Abuse of discretion. The trial court has broad discretion in making a punitive damage award. Where is the clear and convincing evidence that supports the punitive damage claim your client is making?
I'm glad you asked that. The clear and convincing evidence is proof of the evil mind. That's from the case law and the jury instruction.
So but can the court decline to find that there was an evil mind, even though there is proof of an intent to injure and actual injury?
I don't see how that could be.
So every time there's an intent to injury and actual injury, there's evil mind?
Yes, Your Honor. in terms of punitive damages.
Is there a difference in the burden of, the burden of proof? Can't you just find by a preponderance that there's been an intent to injure? And,
Well,
isn't the standard for punitive something more that has to be clear and convincing?
you get into a fascinating dialectical problem here. It's a real, in my mind, it's a paradox. If you prove intent to injure, you can do that by preponderance of the evidence, and here that's established, threefold established. You have established, or as a fact then, at least according to the trial court, you have established that there is the evil mind.
What if it's a close call, and you just come down on the side of, I find this person to be slightly more credible, and both of them have credibility issues, but I'm going to find that there was an intent to injure, but it was not clear and convincing evidence, but there was a preponderance of the evidence that supported that. You would agree that the underlying tort is established, but isn't that a possibility that you could find there's a preponderance of the evidence supports the underlying tort, but I'm not sure that it's clear and convincing evidence?
This is why one reason why I'm not a judge. Justice Jackson wrote this marvelous article in the 50s about appellate practice, but he has a section in there that says, when we're deciding cases as judges, when we write our opinion, it looks like we decided 100% that this is so, when really we're deciding about 51% that this is so. But I think once you pass the threshold of showing that there was intent to injure, whether it's by 51% or 100%, you have established the evil mind. And then you go on to, well, what is the amount of
But you would object
damages?
if there had been a jury instruction that said you have to prove the underlying tort by clear and convincing evidence.
I don't think it says that. I think you have to show the...
But I'm saying, and I'm asking, your client would have objected to that being the jury instruction on the underlying tort, that you had to prove the underlying tort by clear and convincing
Correct.
evidence. So there does seem to be a difference that your client would recognize you don't want to have to prove the underlying tort by anything more than a preponderance.
Correct.
And if the standard for imposing punitives is there has to be clear and convincing evidence, it seems to take it out of the realm of it's necessarily been established by the verdict.
But when you're dealing with an intentional tort, once you've established the commission of intentional tort, you have established for a fact that there has been an evil mind. And so the clear and convincing is really reserved for situations where you're trying to establish deliberate indifference, conscious disregard, those sorts of things. But when you've established that there's an intentional tort, it's established 3 times in this case, you've established that there is the evil mind. And then you go on to...
Let me stop you, counsel. The Superior Court said that discerning the truth is a monumental task in this particular case, and found that your client had established her allegations by a preponderance at best, or barely so. Correct?
Yes,
and
Your Honor.
you acknowledge in your brief that when the plaintiff has proven intent to injure and actual injury under the challenging, clear, and convincing standard needed to establish a right to punitive damages, at that point, plaintiff is entitled to an award of punitive damages. But your client did not establish the intent to injure by that challenging, clear, and convincing standard. Isn't that so?
I'm going to say yes, and can I explain my yes?
So you're going to say that the court did find that that the intent to injure and actual injury had been established by a clear and convincing standard?
I'm not going to say that because I don't think the trial court did that. What the trial court did was to establish as a fact that there was intent to injure, and assault, battery, intentional infliction as a fact. Once you've established as a fact there's intent to injure, you've established that element of punitive damages.
So then we don't need to worry about the clear and convincing standard anymore?
No, I'd worry about it, but in the sense of, okay, there's a clear and convincing standard. However, under the facts of this particular case, when the judge has established as a fact that there was intent to injure, we've satisfied that. We've satisfied any concern over whether there's an evil mind or not. Clear and convincing is there to help the fact finder decide if there was an evil mind. And here, the judge decided there was an evil mind.
By a preponderance of the evidence?
Well, once you decide there's intent, then you've decided the evil mind. As a fact, I think it's beyond a reasonable doubt if you want to throw in a standard.
All right.
Well, that would apply to every single intentional tort then. There's automatically a requirement that some punitive damages be awarded anytime an intentional tort has been committed?
I would say, if I may, I would say it this way, that would be abuse of discretion in the average case not to award punitive damages.
You're
So
saying
yes,
in
and
the
this would be the average case.
You're saying in the average case, what case law supports the fact that it is mandatory if an intentional tort is committed that punitive damages be awarded? What case says that? I haven't found it.
Well, the cases I relied on were the ones, and I cited them in the briefs, the ones that talk about the entitlement to punitive damages. Quiroga, Rawlings, and Wyatt are examples of ones that I cited. Once you satisfy the elements of the punitive damages, the right to the punitive damages, if you will, then you have the entitlement steps in.
How do we rectify that with the fact that in most of the cases it uses may be inferred or implied, may, not shall?
Well, I think those cases don't involve facts as clear as this one, where you have an intentional tort. For Ruby, for instance, goes way off the beam and says, we just don't, this is discretion, if we don't interfere with the decision about punitive damages. But Ruby, although it was an intentional tort case, was an oddball thing, there was no award of actual damages. So there couldn't be no punitive damage. You have to have actual damages first before you get the punitive damages. So Ruby was simply dicta, if you will. Here you've got the evil mind, you've got the injury, and there's enough there that the trier of fact should award some punitive damages. And here would be abuse of discretion not to award the punitive damages because of the evil mind and the injuries.
And where is the case that says that?
I don't think I've located a case like that, but I have located cases that talk about the entitlement to punitive damages, and I think we fit within that sort of thinking, that if you've established the elements, then there is the entitlement.
Okay, so we talk about entitlement versus mandatory nature of punitive damages. You're entitled to it, the court didn't award it. How is that an abuse of discretion?
Well, it's an abuse of discretion because under the circumstances of this case, the punitive damages should have been awarded because there was the evil mind, this clear proof of the evil mind.
By a preponderance, not clear and convincing, in the best.
Well, as a matter of fact, the evil mind was established.
So you believe that anytime an intentional tort occurs, as a matter of fact, the court has no discretion to find there is no evil mind? I could be confusing, Mr. Abney. I'm sorry.
No, not exactly.
So give me a circumstance where that wouldn't happen.
Well, we're talking about the trier of fact. Once the trier of fact has decided that there is an intent to injure, that there were actual damages, consequential injury to the victim, then there should be an award of punitive damages, unless there's something else that takes it out of that realm.
But if you get to, let's even assume there's an entitlement. I can go back to the original, one of the early questions. If it could be $1, what's the difference? It seems to me if there's absolute discretion on the amount to be awarded, you're not suggesting that there's necessarily an award that has to be 1/2 of the damages that were awarded. Is there some standard that you're suggesting that we could apply other than deferring to the trial court's assessment of whether this particular conduct warranted something above the actual damages?
Well, it doesn't seem to me in this case the trial court actually assessed it just said no punitive damages. I'm not going to award punitive damages. But in the proper, the standard is the loose one that the courts have applied of proportionality. If, for instance, there's $1 million in actual damages and you award $1 in punitives, people would be scratching their heads saying, is this proportional or not? Then the court ought to at least do an analysis to say, no, this is not disproportional under the facts of this case. But here that analysis didn't occur. There needs to be some sort of determination by the trial court about the proportionality. What amount is a meaningful amount, a proper amount to award under the circumstance of this case? If you say 0, I think that's abuse of discretion because there's no proportionality to that. 0, 15,000, there's no connection there.
How does Schmidt, the case you cite at page 13 of your brief, Schmidt v. American Leaseco, which you cite for the proposition that whether to award punitive damages and the amount of that award are discretionary questions for the trier of fact to resolve. How does that reconcile with your position?
Well, that works with abuse of discretion. I mean, if it's discretionary decision, abuse of discretion, this judge abused discretion because he didn't award anything at all.
But
But it's
you
whether
even
to
recognize that whether to award punitive damages is a discretionary matter. Whether to award them at all. I mean, I read that as can award them or can decline to award.
I read it slightly differently as to what it says, the whether to and the amount, if I remember that correctly, that case correctly.
Okay, but what doesn't whether to award mean that there's an option not to?
Well, see, there's where you get to the discretion. If under all the facts you have something as clear-cut as here, you've got intent, you've got the injury, you've got actual damages, then in that particular case, the discretion has to be, I'm going to award something. That would be the exercise of discretion as I would view it.
But in this case also, we have Judge Cohen, and I don't know that I've ever heard anybody in a written ruling say, discerning the truth was a fairly monumental task under the circumstances. So we talk about credibility and credibility issues. Clearly, there were issues in this case. I keep going back to, why would they require clear and convincing in one circumstance and a preponderance in the other? When we talk about proving your case, okay, Judge Cohen said you made it 51%. But it takes something more to prove that you're entitled to punitive damages. And then we say whether or not to oppose punitive damages. Can't he say, I'm not going to do it? And why not?
I don't think he can, because once you've established that intent, you've done away with the clear and convincing problem. You have established as a fact, a judicial fact, that indeed there were 3 intentional torts committed. There were actual damages. I'm going to award actual damages. And therefore, you're in a situation now where you need to use your discretion concerning punitive damages and award something. That would be my analysis.
The judge has no discretion to say, nope, this case doesn't warrant punitive damages because you've proven intent in the underlying causes. Punitive damages are mandatory.
Yes. You need to get down to basics. Yes, that's what happens, I believe. Now, the amount is and there again, another discretionary problem. As far as just one more word before I sit down. The judge's language, I think, is candid, but I think the thinking is not unusual. I think many judges wrestle with the problem of, I've got this courtroom full of people, they're telling me different stories, and I got to figure out who to believe or not. And I think he was just a little more open about expressing his thoughts.
If it may please the court, my name is Alex Bergener. I represent defendant appellee Daniel Biederbeck. And as an initial matter, it is our position that the trial court did not err in its decision not to award punitive damages. And as you have discussed with appellant's counsel, we have 2 other objections to punitive damages even being awardable under the facts presented at trial and the decision of Judge Cohen in this matter. The first one is evil mind. It is our position that evil mind is a necessary component of any punitive damage award, that the fact finder would need to make a determination of that. For that, we look to Rawlings v. Apodaca, which is one of the cases appellant looks to for his entitlement argument. And Rawlings, we just take a little bit of the language out for some flavor. They say, we do not believe the concept of punitive damages should be stretched. They go on to say, thus, to obtain punitive damages, plaintiffs must prove defendant's evil hand was guided by an evil mind.
Go ahead.
Go ahead.
Well, counsel, can't we get to the evil mind from the fact that there was intent to injure and actual injury caused? Why do we not get to evil mind from the establishment of intent to injure and actual injury by a preponderance of the evidence?
And that's the other portion that we disagree with, as you've identified as the standard. it's our position that we don't get to evil mind from intentional torts for primarily the same reasoning outlined in Rawlings, which considered whether or not bad faith, which is an intentional tort, automatically comes with punitive damages. And the Supreme Court in that case decided that was not so. Now, they would have us impute the evil mind based on the type of torts. Again, that's been analyzed and dismissed in Rawlings. Here we do have the intent to do harm portion in these torts, but even Linthicum v. Nationwide Insurance held before a jury may award punitive damages, there must be evidence of an evil mind and aggravated and outrageous conduct. So it's our position that based on the evidence presented at trial, there was evidence of aggravated and outrageous conduct, but it's our position that no evil mind evidence was put on. And therefore, without the evil mind being found, that you cannot award punitive damages.
How do you commit an assault without having an evil mind? Explain that to me, counsel.
Okay, it's my position that if we modify these circumstances slightly, this is an event in which a then husband and wife had a slight altercation, or had an altercation, a physical altercation at their home. It's our position, it's Mr. Biederbeck's position, that that was not, he didn't have an evil mind at all. He was just acting on impulse. And we would say evil mind would, for example, be something like, had he, with the intent to do harm to his wife, lulled her to some secret location and then accosted her, or put some forethought into the activity, that would be.
So evil mind requires premeditation?
It's our position that the evil mind needs to be determined by the trier of fact. So in each case, that would be different, and it's our position in this case, the judge did not, in his opinion, come to the conclusion that there was evil mind. So that's our position on the evil mind factor, and you may or may not agree with us. But we have our additional obstacle that we feel that the appellant did not meet is the burden of proof. And you've all sort of discussed that. It would be our position that if you are accepting this imputed evil mind that we believe has been examined and discarded in Rawlings, if you are persuaded by that argument, though, our position is that the underlying torts themselves would have to have been proven with clear and convincing evidence.
And just to keep us straight with our discussion, the court below never found the element of that the element of evil mind had been established.
Correct. And it's our position, therefore, they can do the punitive damages. But even if we're going with the imputed evil mind, our position is those underlying torts would have to be proven with clear and convincing evidence. And for this authority, we looked at page 332 of Linthicum v. Nationwide, where it says, while a plaintiff may collect compensatory damages upon proof by a preponderance of evidence of his injuries due to the tort of another, we conclude that recovery of punitive damages should only be awarded upon clear and convincing evidence. And as identified by the panel, the present case, the court on page 1 in his ruling said each claim must be proven by a preponderance of the evidence. And after doing a credibility analysis of both parties, came to the conclusion that discerning the truth is a fairly monumental task, and he just decided whether or not it was proven by preponderance. So in reply brief on page 12, the appellant states, the clear and convincing standard applies in situations where there is some debate on the existence of an evil mind sufficient to support punitive damages. And we agree with that. We say that this is a situation in which we dispute there being evil mind. Therefore, Linthicum already tells us the clear and convincing standard applies, but even the appellant agrees. So for Judge Cohen's trial ruling, although we didn't agree with all of it, it was well thought out, well written, and deliberate. And so for the reasons I've stated, we ask this court to affirm the lower court ruling. And I'm happy to answer any questions.
No, thank you.
I rise to congratulate my learned colleague for his concision and the brevity of his remarks. I have nothing further to add unless the court has further questions.
I do. Even if we were to assume that there was clear and convincing evidence established an intentional act, isn't that more like it's clear that you intended to hit someone? that doesn't go to the evil mind. You prove that, even if it's clear and convincing evidence, there's no doubt that somebody swung his fist, he knew the person was in front of him, and he hit the person. There's an intentional tort there. How does that necessarily also encompass an evil mind? Without that being part of the jury's charge, to also, you have to have more than just you intended to hit somebody, and it's absolutely clear you intended to do that.
I don't know about that, Your Honor. Let me see if I got the... Okay, engaged in misconduct with one or more of the following states of mind, intended to cause injury.
Right.
But I think once you've established the intent to cause injury,
somebody
you're
swung
there.
their fist intending to cause injury. So
Right.
there's really no dispute about that. That's clear and convincing evidence. He swung his fist, but it seems to me punitive damages does require more than that. It does require an evil mind or something beyond that. And so that doesn't seem like it was part of the jury's charge. It was just, we can even call that clear and convincing or beyond a reasonable doubt that he swung his fist intending to do that. That doesn't seem to answer the next question.
If we're dealing with a hypothetical case, because here there was actual physical conduct, she was picked up, thrown against the security door, kicked aside. So there was physicality here. There wasn't just the assault. There was a battery. But once you've established that has happened, that there is an intent to injure, you have established the evil mind. And here, the trial court, this was a bench trial, the trial court decided that there was. And there was the intentional tort, and that is intent to injure. 3 times over, intent to injure.
How
You've
do we
established the
rectify
evil
that
mind.
with Baker v. James? Here's the language. A battery, which necessarily somebody's hit somebody
Yes.
with the intent to injure. Okay, so a battery entitling a plaintiff to compensatory damages may also entitle her to punitive damages if malice is expressed or may be implied from the nature of the acts. So they address this very situation where somebody intended to hit someone and say, we go back to my question, it's a may, and then we go back to Judge Cruz's question, you're entitled, not you are obligated to court award. So how do we rectify those two things?
I'll give you 15 seconds to answer.
Sorry.
I'll try. If I recall that quote accurately, there was a little bit at the end about establishing that there had been something bad that actually happened. And here we have that establishment, not just an assault with intent or some sort of semi-firm evidence of intent to injure, but you've got the actual injury and clear evidence that he meant to do it. When he picked her up, threw her against the door, and then kicked her inside, he meant to hurt her, and he did. So I think that's enough to satisfy my theory, at least, that there's an entitlement to punitive damages.
Thank you, counsel. We're out of time, and I don't believe that Mr. Bergner wants to concede his 14 minutes to you. So at this time, we
Yes, Your
thank you both for your arguments. This matter is now under advisement. We will take a brief recess to prepare the courtroom for the next argument. Thank you.
Thank you.